Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Social Media Manager for HAR. I'm joined this morning by HAR Legal Counsel Grant Harpold. Grant, welcome.
Hey, good morning.
It's a pleasure to have you back.
Sure, glad to be here.
Yes, and we have a lot to talk about today. But I do want to, again, welcome you all to Member Focus Monday. I know we have a lot of first-time viewers this morning, so if this is your first time watching Member Focus Monday, welcome. We're here every Monday morning at 9 a.m. Be sure to go ahead and like this post and share it because Grant has a lot of great information to share with you guys. And if you have any comments as we're going through or questions, type them into the comments section and we'll get to those very soon. So again, Grant, welcome. Thank you again for being here. I believe this is your fourth visit on Member Focus Monday?
It seems like it,
Seems like it?
Yeah.
So just really quickly for those viewers that are maybe seeing you for the first time, if you could just introduce yourself for us.
Well, I'm Grant Harpold. I'm a practicing lawyer now for 30 years. I'm legal counsel at HAR, board certified in civil trial, and have dealt with a lot of issues that you deal with. Mm-hmm. And so I deal with them from a legal standpoint, but I try to look at them from your standpoint. And so that's why hopefully what we're doing here this morning will help you in going about your daily task today, tomorrow, next week, and so on and so forth.
Very good. And you are speaking at Engage this year, correct?
I am. And I think I'm in the pecan room. I speak at 2:30. Engage is a great program for all, with great speakers, and I'm just hopefully would be one of those at that moment, at that day. And I think we're going to probably talk about legal threats, sort of the kind of the stuff we will touch on today, but maybe in more detail there, and see what else is trending at that point.
Yeah, and any updates because it is about a month or so
Right.
away now. So, and just a reminder, those of you that are already registered for Engage have been entered in a drawing that Grant will pull at the end of this session to win a $50 Supercenter gift card. So we did one last week, and we had a winner last week. And we'll do that again at the end of the session. So stay tuned to the end to see if you won that $50 gift card. So last time you were here, the NAR lawsuit had just been announced.
Right.
I think at this point, several months later, our members are much more aware of it. But if you could just give us an explanation of the lawsuit and maybe give us a current standing, where are we now with that?
Yeah, I mean, in general, the lawsuit is seeking class action status if it doesn't get dismissed. And so currently it's pending. It's pending against NAR and some big broker franchisors. And NAR and the other defendants have filed a motion to dismiss, which is pending before the court. So the case could be kicked out, dismissed by the court, or if it does not, then it will probably go on and on and on and on and see where it goes from there. So that's kind of the current status. The court's sitting on a motion to dismiss filed by the defendants, and no real idea on when that would be ruled on, maybe sometime this year. And so the whole, I guess, nature of the case is that the plaintiffs are contending that the seller has been overpaying in compensation to brokers because of the offer of compensation that's in the MLS rule. I mean, that's breaking it down as simple as really that issue, the offer of compensation for a buyer's broker that's an MLS rule. That's what they're really complaining about, and how that's allegedly inflated the cost to the selling side of the transaction.
Sure.
So that's it.
Okay, so it's kind of a wait and see right
So
now.
wait and see, and that's really it. There's really not much more to say about it as far as.
Do you have any suggestions for our members if clients are asking them about it, what they should maybe say?
My response would be it's lawsuits are things that are very unpredictable, and so it's hard for anybody, lawyer, non-lawyer, to predict what will happen. And so there is a pending lawsuit. The lawyers are dealing with it, and let the court system ultimately, decide who wins and loses.
Okay. So I also want to discuss with you, and we have discussed this on this program before, Trek advertising rules. So
Right.
about a year ago, Trek updated
They did.
their advertising rules, and we get a lot of questions about this from members still to this day. So if you could just kind of clarify for us what changed last year with Trek and advertising.
I think the main thing that is, especially if you're an agent advertising, that whatever advertisement you have and however you do it, is that your broker's name has to be part of the advertising. I mean, and we won't go into detail on that, but just think in that kind of mindset. Hey, if I'm advertising, I need to, as an agent, I need to have my broker's name somewhere on this advertisement, and so that's kind of the key. And the broker's name that you're using, of course, and this is kind of dependent on the broker, it needs to be a name that's registered with TREC, whether it be their corporate name, their DBA name, their assumed name, whatever it is that they're using with TREC has something to identify themselves. That needs to be part of your advertising. And the point of it is, if somebody looks at your advertising and wants to, for whatever reason, contact your broker, they'll see the proper name and they can go to TREC or Google or whatever and find out who are the people behind this broker entity or this name that's being used in this advertising. It's ultimately it's about providing the consumer information and being able to identify A, who you are, and B, who your broker is.
Sure. So if a consumer has, any kind of experience, whatever that may be, good or bad, or questions or whatever, there is a broker that they can reach out to. That's the
point.
The idea.
Yeah,
right?
that is the idea. Is that you are sponsored by a broker, and so if you're going to be out there publishing yourself to the consumer, then let's identify the broker. And I think that was I think generally, well, there was sort of some. It wasn't so clear before, and now it's clear, and it should be fairly simple to incorporate that into whatever advertising mode you're in.
And there was also a change to teams, correct?
Right.
The way teams are labeled.
Right, and they did. I mean, they did take out where you could not use the term realty. They have now put that back in, where as part of your team you can use the word realty, but that rule was simplified, and there it should be simple enough to follow at this point on what your team name is, and once again how it's registered and should be registered with TREC.
Very good. So again, we have HAR Legal Counsel Grant Harpold here with us this morning. If you have any questions for Grant on anything we've covered so far and what we're about to cover, go ahead and type them into the comments and we'll get to those. We're about to talk about the updated seller's disclosure notice.
Oh, yeah.
So the seller's disclosure notice, when was it updated and when did that go into effect?
So it came out of the legislation from last spring, from when they met in Austin, the legislatures, and this was a bill that was, of course, sponsored ultimately in both houses, and the governor signed, and there were other things done, but the important thing we're looking at today is the seller disclosure notice, and it changed the notice. It added about another page of information that needs to be provided to the buyer, and that the seller fills out, and is effective. Now, get this new seller disclosure notice is required for any contract that is entered into from September 1 forward. So it's already the law. Mm-hmm. And so if you have a contract that you're getting ready to enter into, or your client's getting ready to enter into, or was entered into September 1 forward, and you do not have this seller disclosure notice, you need to get it. And you need to update, and you need to make sure that you have the new form. The forms are out. They should be fairly accessible. I would even suggest that even if you have a current listing that predates September and there is no pending contract on it, you might still go ahead and have your seller get an updated seller disclosure notice, especially if it's a property in a flood type area, Houston, let's say.
Yeah.
And so two things to remember here. Effective 9/1, you have to use this disclosure notice on any contract. Even if you don't have a current contract on a property pending that is a listing that goes back several months ago, you should probably still go ahead and get a new disclosure statement from your seller to provide to the buyer, even though you're not required to technically. It's just probably good practice since it is out there and is being used.
Okay. So you mentioned that this came through the last legislative session.
Right.
What was the goal here and what changes have been made?
Well, I mean, it's funny. Harvey kind of died, even though Harvey was really Gulf Coast, Houston. These changes were a result of Harvey, but of course they apply to the whole state. So I'm sure there's some people, not along the Gulf Coast saying, gosh, why are we having to deal with these questions? Well, sorry, it is what it is. And so, but it came about because of Harvey, and actually they were going to, originally the bill that was being floated around Austin was going to require 2 forms you'd have to fill out. One, kind of the traditional seller disclosure, then another form, a flood form. Ultimately, they were able to come to an agreement to provide, all of it in one document, so there wouldn't be multiple documents flying around. You're saying, well, that's probably the positive I can say on it. At least there's not 2 documents you're having to have your client fill out. It's still just one document, but it's increased in size by 1 additional page.
Okay, very good. So let's get into the details here.
Okay.
And we can put it up on the screen for the for people that are watching this to see what exactly has changed. What should we be aware of? What new fields and things like that?
Well, the good news is page 1 has not changed, so we don't need to look at that. That's pretty much the same. And so what we're going to do, we're going to go through this page by page, or at least to the pages that have the material changes.
Excellent.
And we'll throw up on the screen some of those. So we'll go to page 2, and really nothing there at the top portion of page 2 changed, meaning section 2, that reads the same as it did before. But if we go to page 3, section 3, page 2, section 3, and let's put that on the screen if we can. Page 2, section 3, if you look on the right-hand column, about midway down, you'll see where it says water damage not due to a flood event. Water damage not due to a flood event. And I don't know, you ought to be able to see that in front of you or on the screen if you're looking at it. But so that's new. And so obviously that's kind of was, I don't know, actually that's not obvious, but the reason it was stuck there is because all the flood related issues have now moved over to the next page. So you'll see, if you'll recall, in section 3, they used to ask about flooding into the property, flooding onto the property, flooding into the structures. Those questions are not in section 3 anymore. Those questions have been moved to the next page, and we'll look at that in a little bit. But what I think what's important here is this is a new question: water damage not due to a flood event. And you're saying, what exactly is that? And I guess it can be
busted pipe.
Yeah, anything that wasn't from a flood. Mm-hmm. But here's something that I noticed, and I'm not sure how to deal with it, in the sense that used to be right there, if you'll recall, used to say water penetration. Mm. And if you look on here now, there is no question in section 3 about water penetration. And actually that question really doesn't show up at all on the next page. It shows up on the next page relative to flood, but not relative to what I would call traditional water penetration, like from a roof leak or window leak or maybe a door, but typically it was from a roof or from a window, right, and something that was perhaps current.
So this doesn't involve penetration, water
no,
penetration?
No, it doesn't. It says water
damage.
Yeah,
right.
And so those could be 2 separate items. So I think here's the takeaway on that, is that this water penetration seems to have escaped from the disclosure notice, but I think it still might fall under, if you go back to section 2, where to ask about some of the issues, whether a roof is malfunctioning or whether a window is malfunctioning, that may be where that information needs to be captured going forward, because if a roof is leaking, that's malfunctioning. If a window is leaking, that's malfunctioning. And so section 2 hopefully will cover that issue for the seller's sake and for your sake about water penetration, since it's no longer being asked in section 3. So just something to think about. If that issue arises is about water penetration, then that certainly you ought to be able to find a spot in section 2 to cover that, even though it's not specifically mentioned in either section 2 or section 3.
Okay, great.
And so let's go to page 3 and section 5. And so if you look at section 5 on page 3, that's kind of the new stuff, and that is the new stuff. There is some overlap of old questions, but they've been reformatted and they're here. And so let's focus on Section 5, and probably the biggest thing to remember in this section is that it's asking the seller, are you aware? Okay? So the question is, and I'm reading, mark yes if you are aware, mark no if you're not aware. So this is, to kind of, I guess, take the stress off or the pressure off some of these questions, because the seller may not know. And if the seller is not aware, then that's the answer. If the seller is aware, and remind you, awareness is not equal to personal knowledge. You don't have to have personal knowledge. You just have to be aware of it. And if you're aware of it, you disclose it. But if you're not aware of it, then not aware is an acceptable answer. And on some of these, I'm looking at this because I'm a homeowner and I've sold and bought, and I'm looking at something I don't know. I would know the answer, and I would imagine your client, your seller, is going to struggle with some of these new questions on how to answer. And so I think most importantly is go back and have them read what the question is asking. Are you aware? Are you not aware? And that's really what the question is asking. And so if you look down there in Section 5, you'll see some of the ones that you've seen before. Present flood insurance. Here's a new one. Previous flooding due to the failure of a breach of a reservoir controlled or emergency release of a water. Anyway, I mean, we know where that's coming from. That's in relation to attics. I don't know that it's happened anywhere else, but it's kind of an attics dam question, if you will. Previous flooding due to natural flood event. And so this is, that's a little bit more than what the old question asked, and it doesn't say property or structure in that question, but we know from reading the question as a whole, it's referring to property.
Right.
And then the next question, and here's where water penetration comes in, but it's only in relation to a flood event. And now they're back on that one. They do use the term structure. And so anyway, I mean, just these questions are answerable. Okay, they can be answered.
So we do have a couple questions coming in from our members about this.
Right.
And I do see there are a couple questions about the Trek advertising rules. So we'll go back to those in just a minute, but let's stick with the seller's disclosure for just a second. Michelle asked, flood means rising water?
Flood means, sure, rising water. If it leaves the street and comes onto the property, meaning where your property starts, that's previous flooding. And so onto your property. This question, so you look at this, it says previous flooding due to a natural flood event. Remember before it would say onto the property, into the structure. Here, this question is still talking about the property, even though it doesn't mention structure specifically, but it is talking about the property. So if water rises onto your property, that's a disclosure issue. If water penetrates into your structure, that's a disclosure issue. If it penetrates in your structure, then it was on the property. So you would have a yes on both of those questions. So rising water typically is a flood event. Yes. Okay.
And another quick question here from Rhonda. Are we making progress in providing the flooding type of info on the new seller's disclosure for tenants?
There is no. So that's a good question.
Yeah.
And I don't know when that's going to be addressed. We being here locally tried to get a bill through the House and Senate last time that would have addressed that issue, but it didn't make it. And so maybe it will next time.
Yeah.
But you're right. There is no, from a tenant perspective, the landlord doesn't really have to tell you much of anything, especially on flooding. And so I experienced that because I had to rent a house after Harvey, and I was like, and I hadn't had to do that in a long time, and I was like shocked. And I was shocked in the sense that I'm getting no knowledge on this house, really. other than what I might see with my eyes and fill out on the inventory or whatever sheet that is. So back to your question, there is nothing that compels a landlord to disclose that.
Okay, at this time, hopefully there's something down in the future.
Right.
Okay, and I do see a few other questions back about the truck advertising rules. We'll get back to those in just a little bit, but I want us to go ahead and keep going here with this.
And so, if you'll notice here also, there's multiple. I count 1, 2, 3, 4 references, 5 actually. 5 times it references, if you answer this question, yes, attach Texas Realtor Form 1414. And so I think that's a critical thing to remember, that if you trigger that, then attach it. And it's a form. It's really just another form telling the buyer more information about flooding and flood risk and flood insurance and stuff that is helpful. And the only reason I bring that up is I have seen, believe it or not, I have seen litigation involving where this was not provided, that 1414 was not provided for whatever reason. They forgot typically, and it became an issue in the case. I've seen it twice now. And I say that not to scare you, because I don't think they're game changers, but they can become issues. And I think you as the listing agent, I mean, that's where the form's coming from. The seller's getting that from you. And if you as the buyer's agent don't get that form, you need to ask, hey, this question was checked yes, you didn't provide me a 1414. Can we get it? Can you provide it? Even though, the buyer could probably get it themselves, at least in blank. And but anyway, so I think that's a dual issue for both sides. Be sure 1414, selling side, buy side, that you get it. It is passed on.
And just for reference, the form that we've been looking at is TXR 1406.
It is. This is the new,
not the truck form.
Right, and so that's a good point. I mean, so we're the new seller disclosure notice is 1406. And there's the Texas Realtor form, TR form. There is a truck form, and I guess maybe some people might use the truck form. The truck form is not as thorough. The truck form does meet the minimum standards of the law. The TAR, the TR form, is more thorough, and probably is almost duty bound on somebody, at least listening to what we're talking about here today, should probably use, because it's more informative. It's gonna
protect.
Yeah, and it's the whole point. Look, the whole point of the seller disclosure notice is to get the seller, to get information out of the seller, and to be a starting point for the buyer, meaning that the seller disclosure notice isn't going to have all the information, but it should lead the buyer to more information, or cause the buyer to seek more information because of what's disclosed in the seller disclosure notice. That's the whole point of it, is to open the lid up and let the buyer get a glimpse of what's going on. And if they need more information, they at least know that subject exists, and they can go dig out more on their own or somewhere else, or through asking questions or whatever.
Okay, very good. What else?
And so I think so. Just some we can go to. I'll come back to that. Let's go to page 4, and here are some new questions. Section 6 and Section 7, and they're fairly explanatory. I mean, you can see them there. I don't see anything fundamentally wrong or weird or confusing about it. If somebody does have a question, let's hear from you. But I mean, the point is they're new, and they're asking for information that the seller should be able to come up with, and so.
Okay.
It's just more. I think that this is information seeking for the buyer's sake, to see what the seller actually did to the property, or what relief, or what insurance, or anything that once again would suggest or cause the seller to come forward and provide the buyer information about previous flood damage previous flood issues at the property. That's really the design still of Section 6 and Section 7 on page 4. And I think that's pretty much, I have one more, and I don't know that we have this to, I think in Section 12, it's the same question, and this is on page 5, Section 12, but if it's not on the screen, it's the same question that's been there before. It's just asking about filing a claim for damage other than flood damage. Mm-hmm. Since that question is now covered by Section 6, they kind of modified the question in Section 12 to any claim of damage filed except for flood damage, because now that's covered on page 4 in Section 6. So, very good. So anyway, I mean, you have is what it is. I think the important thing is kind of remember what we said about knowledge and awareness and filling it out. I think also just kind of points to remember in that, when you get a seller disclosure notice back from your seller, I think it's incumbent upon you to make sure that they filled it out, that it is completed and filled out. I don't think you have a duty to go line by line to make sure to assure everything they say in there is correct or true. Mm-hmm. But I do think it's important to make sure that they did fill it out completely. And so so that's something to keep in mind. And obviously, if it's brought to your attention that something may be wrong in the seller disclosure notice, then you need to focus in on that and see if there is something wrong based on what you know about the property versus what's being disclosed. So if somebody, perhaps a buyer's agent, whatever, brings to your attention something in the seller disclosure notice that is wrong or incomplete, then maybe you need to then address that now that you have been made aware of it with the seller. But I don't think it's incumbent upon you to make sure everything is correct from start to finish from the get-go. Only if you become aware of something that may be in conflict with what your actual knowledge is of the property. And so that is, I think in this seller disclosure notice, and I'm kind of rambling, so
no, you're fine.
I think the seller disclosure notice is it's obviously it's the law, but I think it starts on the listing side, but I think the buy side has a responsibility here too. Mm-hmm. If you're the buyer's agent, I mean, that's something that you should be looking at also, or if your client has a question, or if something is incomplete, or the issues that that your client is sensitive to, buyer's agent, then when you look at the seller disclosure notice, if it doesn't seem to provide the information you thought would be there, or that is informative to your client, then I think you need to raise those questions. And I think it comes up, especially when you look at Section 2 and 3 on the comment section. I mean, the comment section, when you check yes in Section 2 or you check yes in Section 3, the comment section, I think that's something that can be a critical path of information. And if the information there is confusing or maybe not what you want to see, or maybe you want to see more, then you, buyer's agent, should bring those questions up with the listing agent. And those questions should be somehow documented, emailed. And so, and listing agent, if you get a question from the buyer's agent, you're emailing that question to your seller, and you're getting a response back by email, and you're emailing that to the buyer. I mean, so
and keep it all
documented. Keep it all documented. I mean, I know email is old-fashioned, okay, but I mean, for this type of stuff, I think it's pretty critical, and I think people, for the most part, still use it.
Yes.
And so, that flow of questions that might start from the buy side should all have have the river and flow of emails back and forth, so that we can show that the information is being provided, and you as the person providing that can source it. Sourcing it from the seller. Here's the email. That's a defense. If somebody ever accuses you of saying something about the property that maybe was not true, you say, well, my source was the seller. Here's my email. Same thing on the buyer. The buyer say, well, my source was from the listing agent, or from the seller via the listing agent. Mm-hmm. Here's my source, the email. So it's important to source that.
Bev just said, excellent point. Buyer has some responsibility too. Do your due diligence. So one question that just popped up, she said, just signing on, so I may have missed this. If a seller receives an inspection report during option period and the contract falls through, do sellers have to make a new seller's disclosure now that the report has been handed to them?
Well, there's certainly that question, and the question's still there, that if you seller have an inspection report, I think it's been I think it's in the last 4 years, but obviously that would cover this one. Yeah, section 10, that section did not change. So if you seller in the course of a possible transaction receive a inspection report, then you need to update or amend or supplement your seller disclosure notice. You as a listing agent need to have your seller do that and disclose that inspection report. Yes.
Good. Okay, and again, that's TXR 1406 is the new seller's disclosure notice. Going back to the truck advertising rules really quick, I know we're running close on our time here. Elizabeth just asked, on advertising, is the broker's logo also required?
No.
All right, quick and easy answer there. And Melissa just asked, what about social media like Facebook?
Not a problem. And I have a social media expert next to me, but it's if it's not on the page, it has to be in the account information. So it has to they have to be able to go back or it has to be somewhere, and typically it's in the account information, or what would be, is that the
the
saying?
account information. Yeah, you're exactly right.
That's where it has to be. If it's not on the page, that's where the advertisement is. It has to be somewhere where the consumer can find it, where they go to find out information about you. They'll see this information about the broker, and so that's kind of the theory, is that it's a click away.
And also on the Facebook business pages, they require the information about brokerage services and consumer protection notice to be on there.
Yes.
So make sure you have those on there. Well, that looks like all the questions. Actually, I'm sorry. Victor just said, who is ever exempt from sending a seller's disclosure?
Well, there are situations where you are exempt, and I don't have it's like a foreclosure or an estate, but without relying on what I say, it's very clear in the seller disclosure information that who is exempt, and I think there's like 3, 4, maybe 5 situations that exempt, and they're just thinking. Typically, the reason they have those exemptions is because there's no way the person who now has a property would have any information on the property, and that's typically foreclosure, maybe an estate, something like that. Okay,
very good. That looks like all the questions. Grant, thank you again so much for doing this. But before everybody takes off, we are going to remind you all that HAR Engage is coming up next month. Grant is speaking at HAR Engage. He's going to give us current legal threats. So he might recap some of the stuff we talked about today, but anything that can happen in the next month and a half will, I'm sure, be covered as well.
Oh, as you know, there probably will be stuff, as y'all know.
Yeah, and we're going to go ahead and do our drawing for our $50 Supercenter gift card. The people, if you missed this last week, we started this last week, and the names that are in here are the over 200 people that are already registered for HAR Engage.
Am I drawing?
Yes, you're drawing, and whoever Grant draws here is going to win a $50 Supercenter gift card. So let's see who you got there, Grant.
One?
You have, I think, one. Yes.
All right.
You can read it.
Matt Stanley.
Yep.
Matt Stanley.
Matt Stanley.
All right.
Isn't
that what it says?
Yes, it does. You have a $50 Supercenter gift card headed your way. Well, Grant, thank you again so much for going through all of this with us today. This has been very informative.
God, it was quick.
It was quick.
I was ready to speak another. I thought we had anyway.
Well, I think we need to have you back again soon.
All right. Happy to be here.
Absolutely.
Right.
So thank you again for tuning in for Member Focus Monday. We will be back next week with Karen Driscoll. She's going to be covering politics and your business. So we'll see you back next week at 9 a.m., same time, same place. Have a great week, everybody.